recent case decided by Delhi High Court on 26th of August, which was Sun Pharmaceutical Laboratories Limited versus Hetero Healthcare Limited. So the facts of the case were basically Sun Pharma had first applied for the mark LETROZ in 2001, but which were opposed by Novartis. So it was reapplied in 2010 with a user date of 2001, which was eventually registered in 2016. Whereas Hetero Healthcare had applied for the mark LETRO under class 5 in 2007 and was subsequently registered. Sun Pharma claimed that they have been using the trademark LETROZ for a generic drug for second-line treatment of advanced breast cancer. Now, the issue of the case was Sun Pharma claimed that the mark LETRO was by Hetero Healthcare was infringing upon their mark LETROZ. Sun Pharma had approached the commercial court requesting for dismissal of their mark LETRO by Hetero Healthcare, whereas the commercial court dismissed this application, and Sun Pharma later approached Delhi High Court alleging infringement and passing off against the mark LETRO. Sun Pharma sought for a degree of permanent injunction restraining the respondent from using the brand LETRO. First, let us look at the commercial court's decision. The commercial court held that the mark LETROZ by Sun Pharma was not novel, but was merely the first 6 letters of the ingredient letrozole, which is the international non-proprietary name of a salt. So what is INN, or international non-proprietary name? Basically, INN facilitates the identification of pharmaceutical substances or active pharmaceutical ingredients which have been used in the manufacturing of a drug. And this name, which is also known as a generic name, is universally accepted and is also a public property. Hence, the commercial court noted that the word LETROZ has been derived from the first 6 letters of the ingredient letrozole, which is basically the main component or main ingredient in the manufacturing of this drug. They also noted that the pronunciation of the trademark LETRO and that of LETROZ was completely different, and there was a structural difference and a phonetical difference between the two. On the basis of this and on the basis of the documents produced by Sun Pharma, the court decided there was no prima facie case made out, and hence the application was dismissed. Now, coming to the Delhi High Court's decision, the Delhi High Court bench concurred with this decision of the commercial court, and they too recognized that the word was just derived from the INN letrozole. The court noted that the mark LETRO is a registered mark of healthcare, and the drugs has been in use since 2007, had created a niche for itself among the public. And also this quoted that the Sun Pharma did not produce any document or evidence to establish confusion among the public because of the mark LETRO. The most important part of the decision was where the court held the rationale where it quoted from Sharing Corporation and others versus Alchem Lab, where it said, when the name is derived or coined from the word of a principal ingredient being used in the manufacture of drug, no distinctiveness or exclusiveness can be claimed by the manufacturer. It's very commonly seen under class 5 that the brands that are mostly registered for medicine or pharmaceutical preparations are derived from the name of the active ingredient used to manufacture the said drug. Hence, it is not an innovative or novel thing that is being done. That is why the court very specifically said that when a name is derived or even coined from the principal ingredient being used to manufacture the drug, there is no exclusiveness that can be claimed by the manufacturer. Hence, the court too concurred with the decision and passed an order against the plaintiff.